Paxton should be removed from office because he failed to protect the state and instead used the power of his elected office for his own benefit. And this was wrong.
That is dumber than a bucket of hair. It makes no sense. They're just wrong.
Well, day 2 of the impeachment trial of suspended Texas Attorney General Ken Paxton is about to start. We catch up this morning on the case with the former U.S. Attorney for the Northern District of Texas, Paul Coggins. Good morning to you.
Good morning, sir.
Well, we heard very different arguments for and against Ken Paxton yesterday in a fast-paced first day in court. So what stood out to you?
Well, we learned a lot yesterday. Number one, with 3 of the 4 attorneys, lead attorneys, basically criminal lawyers, we found out that they're really going to follow criminal procedures or use those at least as analogies. So, for example, Ken Paxton is not going to have to get up on the stand and assert his Fifth Amendment, which is very similar to a criminal proceeding. We also learned that the defense magic bullet, which they hoped would derail the case, didn't get much traction. You know, the idea that nothing prior to his re-election could come in, it really only attracted 6 senators. And I wasn't surprised by the outcome. I was surprised by how few people voted for it. I mentioned yesterday that they would start and end with a strong witness. That means a whistleblower. So they've started with a whistleblower, and he'll resume his testimony. But I think the big thing we learned is there's a huge looming issue here that Lieutenant Governor Paxton and his aides are going to have to handle, and that is the privilege issue. The Paxton team is going to argue that a lot of the conversations and a lot of the documents are protected by privilege and can't come in. On the other hand, the prosecutors are going to argue that, first of all, there's no privilege. Second, if there's a privilege, it belongs to the office and not to Mr. Paxton. And third, any privilege is wiped out by the crime fraud exception. So that privilege issue is going to keep cropping up until it's finally put to rest by Lieutenant Governor Patrick.
Well, and I think, as I understand, that's what held things up yesterday. They were kind of hashing that out at the end of the day, whether or not, and you say privilege, meaning, you know, some of these statements that they're bringing forward, some of the apparent evidence is conversations, I guess, that his staff had. And so they're claiming, well, these conversations are under attorney-client privilege and can't be disclosed, correct?
Absolutely right. That's why we had a slightly early adjournment yesterday, is because I think they're huddling now and trying to figure out, does Paxton have a privilege here? Can it be asserted by him? All these kind of issues, and they're going to keep cropping up because a lot of the testimony that the prosecutors want to bring in have to do with conversations that Attorney General Paxton had with his staff. I think the other thing that we found out yesterday is, you know, the old game, where's Waldo? Where's the Attorney General? He showed up at the beginning, but he was basically allowed to leave. So we don't know how much of this trial he's actually going to attend.
All right, and I wanted to ask you more about this. I'm running out of time with you, unfortunately. So the Dallas Morning News apparently was reporting that House managers had intended to call Paxton as a witness. Then Dan Patrick, of course, ruled yesterday, as you mentioned, Paxton won't have to testify. How important will that be?
Well, it's important in one respect. Even had they been able to call Paxton, he would have asserted his Fifth Amendment rights to every question. He would have answered his name and then taken the Fifth Amendment to everything else. But what, as I said, they're really following the criminal procedure. So in a civil deposition, they can force you to actually assert that Fifth Amendment. Right. But in a criminal case, you can't call, the prosecutor can't call the defendant to the stand and make him or her take the Fifth Amendment in front of the jury. Since they're kind of using the criminal cases and analogies, Paxton will not have to get up on that stand and assert the Fifth Amendment to every question. But bottom line, he wasn't going to testify substantively anyway.
Yeah, all right. Well, we'll see how it plays out today. Always a pleasure to talk to you, former U.S. Attorney Paul Coggins. Thanks for your time this morning.
Thank you.